Peace, love, and law. Today we're going to go over a little bit of the information that is within the Senior Courts Act of Belize 2022. Mainly what we're going to go over is the part 3. I'm going to go scroll to part 3 so we can see what that is. Actually, you know what? It's actually sub-part 3. There you go. We're going to go over law and equity. Law and equity. Why? Well, I am currently preparing myself for a hearing regarding a claim that I have put into the High Court and pursuant to the Senior Courts Act under trust, under law, under equity, and there's going to be an equitable claim. So this is why I want to read up on this a little bit more. I've read it already, but I want to read it over and over and over and over again. So I said I'm gonna read it with you guys. Here we go. So part 3. Now I'm gonna show you something. Right? Let me show you this really quick. This right here is a certificate that it's a certificate of a trust, right? It says a trust exists. The details of it I'm not gonna go into right now. But the details of it, let's say that's private, right? But this is something you can see public. I can share publicly. It is a trust that was recorded. It was basically an assignment to the trustees, which is in this case right here, the Minister of Finance of Belize and the Accountant General of Belize, and they were assigned as trustees. And this is under the laws of Belize, so therefore, because it's under the laws of Belize, it can be enforced in the High Court. And which laws? Well, under equity, right, and under trust law. But I'm mainly read about on law and equity. So it says here in section 38, law and equity to be concurrently administered. Okay, you see how it says right here in this section here, you see this? It says law and equity to be concurrently administered. So it's saying law is one thing, equity is another. They're going to be running along concurrently. So what is law and what is equity? To me, I look at it as law is more like the commercial laws, because it has to do with commerce, has to do with fiction. And then there's equity, that's more in the private, that's more your private rights that you have in commerce. You have an interest in a person in commerce, which is your legal person, and you have an interest, and therefore you have an equitable claim in your person. So right here, section 38 says, subject to the express provisions of any other act, in every civil cause or civil matter commenced in the court law and equity shall be administered accordingly to this subpart. Okay, so in every cause, every civil cause or any matter commenced in the court law and equity. So I would say court law would be like also, I'd say magistrate courts, because it's all commercial. And equity shall be administered accordingly to this part. So that's very interesting, because now I look at the inferior courts and the superior courts. I can see certain distinctions. In inferior courts, I would see more, it's like that, what they're calling court law, which is commercial laws. It has to do with creditor debtor, it's always a creditor debtor. So, and equity, they would still have to recognize some part of equity, meaning that if it's not in their jurisdiction, if they have no jurisdiction to administer it, then they should move it on up to the equity side, meaning take it to the superior court. So section 39, equities of claimant. All right, so if you're the claimant, this is some of the equitables or equities that you have. 39, if a claimant or a petitioner claims to be entitled to any equitable estate or to any right or to relief on any equitable ground against any deed or against any instrument or contract or against any right or any title or any claim whatever asserted by any defendant or respondent in the cause or matter, or to any relief founded upon a legal right, which formerly could only have been given by a court of equity, the court or the judge shall give to the claimant or the petitioner the same relief as may now be given by the High Court of Justice in England in a suit or proceedings for the like purpose properly instituted. Yeah. So obviously that's a lot of words in one sentence, right? So basically, it's just talking about if a claimant, I'm going to read it again, right? If a claimant, because I like to read it over and over again. This is only for you who are interested in these kinds of things, right? So I know the audience is small. If a claimant or if a petitioner claims to be entitled to any equitable estate or any right, or he claims to have any relief on any equitable grounds, and it could be against a deed, if he claims to have any equitable relief against any instrument or any contract, right? Or if he claims to have a right against any right whatsoever, right? That's what it's saying, any right whatsoever. Equity is all over the place. A claimant is claiming to have a right in anything. It could be a title, or it could be a claim, whatever asserted by any defendant or respondent in the cause or matter. Or, if he claims to be entitled to have equitable right to any relief founded upon a legal right, right? So this is commercial now. If he has an equitable right, even in commerce, which formerly could have only have been given by a court of equity, which even a court of equity gave it, which a high court gave it to maybe a senior, an inferior court, right? So even if it's in an inferior court, the court or judge shall give to the claimant. So if he has any claim whatsoever, he shall give to the claimant, or he shall give to the petitioner, the same relief as may now be given in the High Court of England. So anything that we can do right here in Belize that was given, that is available in England, right here is the same thing. The court is to recognize the same thing. That's what it's saying, right? In a suit or in a proceeding. That's how I'm interpreting that now. So 40, section 40. That's a lot of words, man. That's a gumbo of words. It's like, you remember the soup that had all the letters in the soup and it's all mixed up? That's basically that. It's Campbell's. This was written by anyway, let's get serious. Section 40, right, talks about equitable defense. So this one was just as a claimant. If you're bringing in a claim, right, you're the claimant. This is like for a defendant now. You have a defense now, right? So if a defendant claims now, if the claimant, now the defendant, now let's say you go to a lower court, an inferior court, and they're making charges against your person, right? But you feel that you're entitled because they're saying you're a defendant, right? You are driving without a license and you're not showing insurance on your windshield or whatever. The Crown deems that you have offended the king, and therefore we shall charge you, right? That's what the Crown does. So then now you're the defendant. Now you claim you have some entitlement to an equitable estate or an equitable right, or you have and you're entitled to have a relief on any equitable ground against any deed, any instrument or contract, or against any right, title or claim asserted by any claimant or petitioner in the cause or matter, or alleges any ground of equitable defense to any such claim of the claimant or petitioner, the court or the judge shall give to every equitable estate the right or ground of relief so claimed, and to every equitable defense so alleged the same effect by way of defense against the claim of the claimant or petitioner, as the High Court of Justice in England may now give, if the like matters are relied on by way of defense in any suit or proceedings instituted in that court for the like purpose. Basically the same thing said in the top right here, same thing was said here, but just for the defendant. So everybody, you're a claimant, you're a defendant, you have equitable rights. It don't matter. Equity is for anybody, any man or woman can claim that, right? So there you go. Now 41, counterclaims and third parties. Okay, so we're dealing with counterclaims. So not only, let's say, Chandan Makijani, you have been deemed a criminal. You have offended the king, and now you must pay, and you're a debtor. And now Chandan Makijani is a defendant. But through equitable means, he asserts his claim, and now his claim basically gets ignored by the lower inferior courts. Okay, so Chandan says, no problem, accept the charges, give me the bill, I will settle this through equitable means. So Chandan then does a counterclaim, right? Let's say he chooses to do a counterclaim. Let's say he does. So this would be good for him to know. What does that involve? What is that all about? So 41, the court or judge shall have power to grant to any defendant in respect of any equitable estate or right or other matter of equity, and also in respect to any legal estate or any legal right or any legal title claimed or asserted by him. Now, here we go. All such relief against any claimant or petitioner as the defendant has properly claimed by his pleading. So that means his paperwork needs to state exactly what needs to be stated, right? It needs to be supported, what it needs to be supported, provided what needs to be supported. As long as that paperwork is good and that claim goes in, right? And as the court or judge might have granted in any suit, a lawsuit instituted for that purpose by that defendant against the same claimant or petitioner. And B, all such relief relating to or connected with the original subject of the cause or original matter. Subject of the matter. So claimed in like manner against any other person, whether already a party to the cause or matter or not. Okay, anybody who has been duly served with notice in writing, okay, of the claim. It has the individual who's going to be, it has to be anybody, it can be anybody, but they have to be duly served with a notice because of the doctrine of notice, right? In writing, it has to be in writing, it can't be telepathic. Okay, I get it. Of the claim pursuant to the rules of the court. So you got to go by the courts of civil procedure. Okay, so that would be this right here. You see this is the courts of civil. Here we go. Boom. Senior Court Civil Procedures Rules 2025, and get the updated version because these people, man, they always updating stuff, man. So as long as it's proper claim, as long as your claim is good, as long as it's going by the rules of civil procedure, right? Rules of the court or any other order of the court, as might properly have been granted against that person, if he had been made a defendant to a cause duly instituted by the same defendant for the like purpose. Okay. So basically just saying that the court and judge will grant these things to the defendant if the defendant does what he needs to do, conduct himself how he needs to conduct as per the law, what requires, which is to give proper notice, give to the court the claim properly as per their rules, as per their requirements, not how we want it. And basically, if we do what we got to do in equity, they're gonna honor equity, right? Especially in counterclaims and third parties and such. So, makes sense. Makes sense. Subsection 2 says every person served with any such notice as aforesaid shall thenceforth be deemed, who talks like this, a party to the cause or matter with the same rights in respect to his defense against the claim as if he had been duly sued in the ordinary way by the defendant. Okay, so everybody who's served with any such notice of the claim, and they're a party or not, in respect to, okay, so it's basically anybody who's properly served. I get it. That makes sense. Let's move on to section 42. Equities appearing incidentally. Okay. What does that even mean? What is equities appearing incidentally? What is that? I don't even know what that means. Let's check it out. I kind of know. I don't really know. Right now, I don't know. Let me check it out. Let me just confirm, right? Where we go? What does the term mean? Equities. Okay. Okay, equities appearing incidentally. Okay, how about we let me ask chat, my bad. Let me ask chat. Chat's a little bit better at this. I'm not gonna say it's 100%. Can never say that. Regarding law and equity. Okay, there you go. Let's see. What do you got, chat? Tell me. In strict legal language, especially from the perspective of a judge who has lived in the trenches of equity for decades, equities appearing incidentally is a warning label. Here, in the essence, plain and sharp, meaning, when a court says equities appearing incidentally, it means equitable consideration shows up in the background of the case, but the court is not being asked to exercise its full equitable jurisdiction, and those considerations do not change the nature of the claim. In other words, equity is not the primary basis of the proceedings. It just arises on the side as part of the factual matrix. Why this matters? Courts distinguish between equitable claim, and this goes for trusts, injunctions, specific performance. You see, this trust is the main one. You see that, right? In equity, trust, injunction, specific performance, accounting, interesting, rescission, equitable estoppel, tracing, fiduciary breaches. See, it's our trust. It's our trust. You trust the accounts holds value, right? Or accounting of valuable stuff. Rescission of what? Signatures, perhaps, right? Signature is valuable. Equitable estoppel is saying equity. Injunction is an equity. So, separate from legal claims that have to do with debts, debtors and creditors of a contract, have to do with torts, statutory actions. See, statutory, that's inferior courts, magistrates courts. That's what I'm saying. Those statutes, those legislations, man, those are legal claims regarding debtors and creditors via implied contracts. Interesting. If equity appears incidentally, the court will not switch into full equitable mode. Okay, so it's going to be like, wait a minute, let's see if this has to do with a debtor or creditor right here first. You know what I mean? And then see. It will not apply equitable remedies unless specifically invoked. Isn't that interesting? It will not depart from strict rules just because something feels equitable, right? So you gotta claim that right, man. Because if you don't claim it, it's gonna be assumed you ain't asking for it. So you know what I mean? It will not treat the matter as an equitable cause merely because equitable ideas show up. You know what I mean? You gotta, hey, equitable relief, I want it, I need it, I'm asking for it. You know, obviously you don't do it like that, but you gotta claim it, you gotta express it, you gotta voice it out, you gotta stand, you know, you gotta express, invoke that equity. Judges with deep equity experience take this distinction seriously. They are suspicious of parties who try to smuggle in equitable conclusions without actually establishing the equitable cause of action. So, it's basically saying that you got to establish your equitable cause. You got to establish your actions. You got to come in an equitable manner, right? So, it says here, concrete example, if someone sues for a legal debt, but mentions the trust relationship in the background, the court may say the trust is an equity appearing incidentally. Oh, there you go. Meaning, it's not the main issue, and it does not transform the case into an equitable one. Why this is crucial for your work? Given the nature of your trust-based claim and equitable settlement arguments, this concept is dangerous if ignored. If you introduce trust or equitable right only as background, without anchoring your claim in a clear equitable cause of action, a court can dismiss it as equities appearing incidentally, insufficient to invoke equitable jurisdiction. That is the exact critique a seasoned equity judge would fire back. Now, if your remedy requires equity, if it requires equity then, and yours absolutely does, you must do the following. You must frame the cause of action itself as grounded in equity. You must show the fiduciary relationship. You must show the obligation being breached. Show why legal remedy is inadequate, and request an explicitly equitable remedy. So you got to do all these things here, or otherwise the court will treat your points as incidental fluff rather than jurisdiction triggered equity. If you want, I could walk you through the frame. Chad, I was trying to walk me through something, man. So basically, that's what this is about. Section 43. No cause or no proceedings at any time pending in the court shall be restrained by prohibition or injunction. But every matter of equity on which an injunction against the prosecution of any such cause or any such proceedings might formally have been obtained, whether unconditionally or on any terms or conditions, may be relied on by way of defense thereto, provided that nothing in this act shall disable the court if it thinks fit to do so from directing a stay of proceedings in any cause or matter pending before it, and any person, whether a party or not, to any such matter or cause who would formally have been entitled to apply to any court or to restrain the prosecution thereof, or who may be entitled to enforce by attachment or otherwise, this word right here, by attachment or otherwise, that word there, attachment, like, you know, that driver's license thing. You know, if you have a driver's license, it implies that you've accepted the contract and the liabilities attached to it. Yeah, by attachment, because there's a liability that is being implied. So let's say you're driving with a license, right? And they're going to imply that you need one. And you're going to say, oh, I have one, but it's expired, or I left it home. Well, it's already implying by your conduct that you've accepted the attachment. You're attached to the liabilities which needs to be secured. So if How are you going to secure those liabilities? Then they ask you to get an insurance, right? The insurance is proof of securing those obligations. They want you to secure it, or else they got to secure it. And they ain't going to secure it because they're broke. They're bankrupt. They don't got how to secure it. So we got to secure it one way or another. So anyway, or otherwise judgment or decree. So what I'm going to do in this one, right? Let me see if I can. I'm going to plug this right here in chat. I'm going to say chat. Please break this down. Now you see, I've already programmed chat a certain way. I have them on the settings to really, be challenging me, not be so positive. I've fixed it. I had to fix it because chat can be a little bit just positive. Yeah, you can do it. You know what I mean? Like, all right, man, but I want you to challenge me, man. I want you to, so I already programmed chat to behave a certain way to adapt the accumulation of experience of 12 judges with 30 years experience each, and they know they've read at least 50 books of maxims of equity, and I just, I tell chat, this is what I want you to be. I want you to be super smart, and in that way, when I ask you to break something down for me regarding the acts or the legislations or any legal document whatsoever, publication, then I want you to use that to give me your response. So please break this down. Into simpler words. What's going on here? I can't spell simpler words. Two. You see, the thing is that this right here, these legislations, these things right here, they're written in like legalese, you know what I mean? And it's like, I'm reading to you guys, I know you guys are like, what the hell does this mean? And then at the same time, I've learned to interpret some of it pretty good, fairly easy, but at the end of the day, it's still a little complicated, it's not easy because I don't speak like this all day, every day, so I guess you'd have to speak this frequently, and then you could understand it much easier, but then you gotta like readjust your mind and stuff, because it's legalese, man. It's just weird how they write. They write like they're retarded. There's the same section in simpler language, okay, but still precise enough to satisfy a judge who cares about accuracy, okay. In plain English, breakdown 1, you can't stop a court case by asking for an injunction or prohibition anymore. You cannot do that. You can't stop it. In the old days, you can go to a different court of equity and stop a legal case. That system is gone. Okay, it's done. Don't ask for it. It's gone. But number 2 says if you have an equitable reason why the case should not continue, you can raise that reason as a defense inside the same court. The equity doesn't stop the case automatically. You must argue it as part of your defense. The provision, okay, the section, but if, okay, all right, there you go, section. So subsection A, the court still has the power to put the case on pause. That's what stay the proceedings mean. You see what I'm saying? They say stay the proceeding. It's just that it means put the court on pause, right? Stay the proceeding. Who speaks like that? Hey man, I need you to stay the movie a little while. Just stay it there for a little. It sounds retarded if you say that, right? But that's what I'm saying. But it's legalese. So stay the proceedings. If it believes doing so is appropriate, it'll pause it if it thinks it's appropriate. B, anyone, even someone who is not a party to the case, may ask the court to pause the case if, in the old system, they would have had the right to go to an equity court to stop it, or if they have a judgment or if they have an order that is being disobeyed by the continuation of the case. This person may apply by a simple motion, just giving a motion, here you go, and the court will make whatever order is just and fair. Okay, that's interesting. That's very interesting. Here's an even simpler summary. Okay, I need that. Who doesn't, right? You can't go to another court to stop a lawsuit anymore. If you have an equitable reason to stop it, you must raise that inside the same court as a defense, not as a separate injunction. The court can still pause the case, stay, if justice requires it. Even people who aren't parties can apply for a stay if the old rules would have allowed them to stop the suit. Why this rule exists? Well, historically, law courts and equity courts were separate systems. Now, this rule merges them. Equity must be argued inside the same case, not by running to another court for a blocking order. That's interesting. That's pretty interesting. Honestly, that's really interesting. That's why there exists public and private, because there's always room for defense. Yeah, that's interesting. Okay, so section 44, common law and statutory rights and duties. Talks about cap 2. Okay, let me see what cap 2 is. Imperial laws extension. Imperial laws extension. Okay, interesting. So, section 44, subject to the provisions of this act relating to giving effect to equitable rights and other matters of equity, the court or the judge shall give effect to all legal claims and demands and all estates, titles, rights, duties, obligations, and liabilities existing by the common law of England or by any custom subject, however, to the Imperial Laws Extension Act or created by any law, don't matter, any law, in the same manner as those matters may now have been given effect by the High Court of Justice in England. Okay, so this is pretty interesting. Let's break it down, right? Let's see if Jack can break it down. Please do the same for the following. Plain English. Plain English breakdown of section 44. 1. The court must still apply all legal rights and legal rules, including claims, duties, obligations, titles, and liabilities that come from the common law of England or the local customs, as long as they are recognized customs, right? The Imperial Laws Extensions Act or any law passed in Belize. Hey man, you know this thing right here, to recognize, as long as the custom is recognized, you know what I mean, they must apply the rights. You know what this makes me think just now about? One of the things I noticed that, like, especially in the U.S., right, the people post, like, they have all these Luciferian religions and Luciferian cults, and they do all these weird things, right? Now they can claim, I'm just saying, right, it means that they can claim that what they're doing is customs. You know, like they've been doing it for many centuries, whatever. They can claim that, right? And that's a custom now. And if they get their religion recognized by the state, then the state will recognize that they have legal rights. Isn't that interesting? It's very interesting. Two, let me move on. The court must apply these legal rules the same way the High Court of England would apply them today. So in other words, the standard for applying legal rights mirrors the English High Court's approach. Three, this is all subject to the provisions of this act related to giving effect to equitable rights, meaning that if law and equity conflict, equity still controls where the act says so. Equity still controls where the act says so. But otherwise, the court must faithfully apply legal rights. That's commercial. It's all commerce, man. Everything's commercial in the public, you know. So there's a simpler version. It says even simpler. The court must enforce all legal rights, all legal obligations that come from English common law, local customs, or Belize statutes, don't matter. It must do this in the same way the English court would. This is an extension, right, from the English court. This applies unless another section of the act requires equity to override the legal rule. Damn, equity still prevails, right? Equity is still the highest. Core meaning in one sentence, the court must apply the full body of legal rules just like the English court, except where this act should say equity should overrule those legal rules. Here's Section 45. This has to do with determination of matter completely and finally. Okay? The court, in the exercise of the jurisdiction vested in it by this act, the court shall, in every case or matter pending before it, shall grant either absolutely or on such terms and conditions as the court thinks just, all such remedies, whatever, as any of the parties thereto may appear to be entitled to in respect to any legal or equitable claim properly brought. Listen to it. Respect to any legal or equitable claim properly brought forth. We gotta properly bring it forth, right? Bring it forward, and there you go. By them, in the cause or in the matter, so that, as far as possible, all matters in controversy between the parties may be completely and finally determined. The Court of Equity wants to determine it there. They just want to make it determined there. Who has the equitable rights? If he's claiming equitable rights, let's determine it. Okay, good. That should be granted, and that's it. No more anything else. That's it. We know he has the rights. You know what I mean? So anyway, finally determined, and all municipalities of legal proceedings concerning any of those matters avoided. Let's ask chat to give us a simplified version, right? Please do the same for this. Plain English break section 45. Number 1, the court must use all the powers given to it, legal and equitable powers, and in every case, the court should give whatever remedies the parties are entitled to, whether those remedies come from law, commerce, commercial, or it comes from equity. 3, those remedies can be granted outright or with conditions. It can be with conditions, depending on what the court considers fair. Okay. 4, the court is to settle everything between the parties in one case. That's it. That's right. So that all disputes arising out of the matters are resolved and there's no need for multiple lawsuits. So then and there it's going to be done. From here on, no more lawsuits, no more none of that. So an even simpler version of this is that the court can give any legal or equitable remedy a party deserves. It can give that remedy fully, or it can give it with conditions. The court should aim to settle the entire dispute in one case and to avoid extra lawsuits. So wants to deal with it then and there. The whole shebang. Core meaning in one sentence, the court must deliver whatever legal or whatever equitable remedy it deserves on fair terms. So the whole dispute is resolved once and for all. This one's nice. Section 46 says rules of equity prevail, subject to the express provisions of any other act in questions relating to the custody or relating to the education of infants, and generally in all matters not particularly mentioned in this act, in which there are formally or in which it is any conflict or variance between the rules of equity. If there's any conflict between the rules of equity and the rules of the common law in England with reference to the same matter, the rules of equity shall prevail in the court so far as the matters to which those rules relate are cognizable, meaning as there's jurisdiction by the court. So you see, right here, it basically explains how when they say equity in law, they're saying it's equity in common law, right? It's the common law. The common law back in the days, they dealt with when the money involved, the money had substance. So that's when gold was money. Gold was substance. So gold, because being substance, and if you trade gold or something that represents gold, you're not giving an IOU. You're not giving a promise to pay, or you're not giving them an order to pay. You're literally paying it off. Promissory notes, orders to pay, bills of exchange, fiat currency, those things don't pay anything. Those things settle, discharge or settle. That's it. Doesn't pay. That's not payment. That used to be payment when it represented gold or silver. That was common law back in the days, but common law changed when they took out the gold standard. Now that all the money that is used, it's all fiat, it's all merchant law, it has to do with creditors and debtors. It is commercial. Common law is commercial law, but it recognizes equity. Right? So that's what I'm saying, is that when I look at all these statutes, and then these attorneys are saying, yeah, it's common law, it's common law. I've heard police officers tell me that we don't have common law right here. We don't have common law. And then you point it out and say, oh, that's the old time. We don't use that. I'm like, what? What are you even talking about, man? But anyway, that's what I'm saying, is that equity right now is best to look at it. Equity and commercial law. It's all commerce. And once you understand that, then commerce, you understand that it's all fiction. It's having to do with fictitious characters, because in a creditor-debtor world, or in a creditor-debtor contract, these are all fictions. It involves corporations, businesses, associations, partnerships, sole proprietors. These are all taxpayers, citizens. These are all fictitious entities. We, the living, if we want to actually pay for something, we trade something of value for something of value, something tangible, something of substance. So if I grow vegetables, that's my substance. That's what I could trade, my substance, for somebody else, rice, or I don't know, potatoes, whatever. But that's equal exchange. This is like gold for silver, and silver for they used to, gold for animals, silver for silk, or whatever. So because that changed, now it's commerce. Anyway, it's done, right? I finished the subpart 3. But anyway, thank you for joining me along this journey of law and equity and under the Senior Courts Act. And I will let you guys know how my claim goes, man. I'll let you guys know, you know what I mean? So you can see it's right there, you know what I mean? It's there, it's right there, see? So I'm making my claim, we'll see how it goes. I'm going to be studying more equity, I'm going to be sharing more with you guys, and until later, peace, love, and law.